As far as housekeeping goes,
Mhm.
I will be
Mhm.
watching the chat and the Q&A. And so if you have any questions, feel free to either put them in the chat or the Q&A box. At the very end of the presentation, we will have time for live Q&A, and I will promote everybody to be able to ask questions through your voice. And so if that's more comfortable for you, please feel free to write your questions down and ask them that way at the end. Um, I I do want to say that we are really thankful for you guys joining us today as our third Thursday series at the Native Agriculture Financial Services. This webinar is funded through the Ag FTAP program, so the Agriculture Finance Tax and Asset Protection Education Program. And we are the Native Agriculture Financial Services, and our mission is to be a reliable, trusted partner in providing capital to support agriculture production, rural business development, and rural infrastructure for Native American farmers, ranchers, and agriculture communities. And we're really thankful to be a partner of the Southern Risk Management Center, and that is where our funding is coming through. Today, our presenter will be Mr. Ridge Howell. And at this time, I'm going to go ahead and turn it over to Ridge and let him get started.
Good afternoon, everybody. Thank you for joining us on this webinar today. We are going to be talking about the NAD appeals process, or the National Appeals Division process. This presentation is supposed to be an overview of the filing process, common questions that come up for producers who are interested in filing a complaint, and give you a little bit of an idea on what the timeline, rollout of decisions, and all of that good information is. And this presentation was put together by myself and NAFS CEO Janie Simship. So we're going to start off just with an overview of NAD's purpose and mission. NAD is a part of the USDA that was established in late 1994 in the wake of a broader USDA reorganization. The mission is to conduct impartial administrative appeal hearings and review of adverse decisions made by designated agencies within USDA. And the statutory basis for NAD is found at 7 USC section 6992, which states that the Secretary of Ag shall establish and maintain an independent national appeals division within USDA. So what led to the creation of NAD, and why is it relevant to Native producers? This is a long drawn out answer, but to kind of sum it up, it really started with the 1980s farm crisis. That period highlighted so many issues that farmers and ranchers face in the American ag landscape. And one of those big issues was failure on USDA's part for addressing discrimination complaints, which were found to be inadequate and systemically biased against minority farmers. As the 1980s farm crisis was developing and continuing, lots of murmurings were happening that class action lawsuits were going to be filed against USDA. And during that period, Congress decided to be proactive and take initiative to restructure how complaints were heard. And that led to the passage of the Department of Agriculture Reorganization Act, which is where NAD was originally founded. Although there were two landmark class action lawsuit discrimination lawsuits in Pigford versus Glickman and Keepsiegel versus Vilsack, they were filed shortly after the creation of NAD in 1997 and 1999, respectively. But the discrimination complaints that those cases were built on happened throughout the 1980s farm crisis and into the 90s, and were really instrumental in both identifying the issue of not having a proper process for addressing discrimination complaints. And they were really formative in pushing Congress to go ahead and make a big reorganization of how USDA functions. Why does NAD matter? If you remember one thing from this presentation, I'd tell you it should be exhaustion of remedies. So there's a exhaustion of remedies mandate within USDA statutory and case law. And essentially it means that prior to suing either the Secretary of USDA, USDA itself, or one of the USDA agencies, there's statutory and case law that requires exhaustion of all administrative remedies. Put a little bit more simply, you cannot sue USDA unless you have exhausted the administrative remedies that are offered through NAD first. So because we have that mandate, it's so important that you protect your rights. And that first right is an administrative remedy right, and NAD offers it to farmers and ranchers so that they can pursue remedy without needing to hire an attorney and file a lawsuit. So people, if you have a farm loan that was denied, if your mortgage was accelerated, maybe you've been denied a program payment or assistance through a USDA program, you likely have the right to a hearing before a fair and impartial NAD judge. So kind of an overview of what NAD is. To start off, I think it's important to kind of place where case law and statutory law is on NAD. So as things that apply to NAD, we have the Administrative Procedures Act and the Equal Access to Justice Act. On the other end, in a NAD scenario, we don't have the federal rules of evidence to apply. Um, while they don't apply to NAD proceedings, the agency still has the ability to exclude any irrelevant material or repetitious evidence that was submitted as part of a NAD appeal. There is a standard of review of substantial evidence for NAD appeals. We've got a couple useful quotes on here that kind of explain what that is. The first one is that evidence may be considered substantial even when two inconsistent conclusions might have otherwise been drawn from it. And a reasonable decision is one supported by substantial evidence, which is more than a scintilla, but less than a preponderance. And with that, the appellate has the burden of proof. So the person appealing the decision has that burden of proof to prove. NAD subject matter jurisdiction. It is described at 7 CFR section 11.3. And it states that regulations contained in this part are applicable to adverse decisions made by an agency. And then those 4 bullet points give some examples of what those decisions might be. It could be a denial of participation or receipt of benefit under any program or agency within USDA. It could deal with respect to compliance with program requirements, the making or amount of payments or other program benefits that a participant in any program of an agency had, or determination that a parcel of land is a wetland or a highly erodible land. Really importantly, what USDA agencies does NAD apply to? There are 9 of them, and they are also found at 7 CFR section 11.1. These USDA agencies are the Commodity Credit Corporation, the Farm Service Agency, the Federal Crop Insurance Corporation, NRCS or Natural Resources Conservation Service, Risk Management Agency, Rural Business Cooperative Service, Rural Development, Rural Housing Service, and the Rural Utility Service. So, who can appeal to NAD and what can they appeal? The first part, who is the participants? We've got a definition for what a participant is under NAD, and it's any individual or entity who has applied for or whose right to participate in or receive a payment, loan, loan guarantee, or other benefit with any program or agency to which NAD or to which the regulations in this part apply is affected by a decision of such agency. So if you're a participant in a program under one of those agencies listed on the prior page, and there was some issue with receiving payment or a benefit of that, you are likely a participant who can file a complaint through NAD. What can you appeal? It's an adverse decision. These are administrative decisions from an agency that was listed on the previous slide that are adverse or opposing or negative to a participant. So in short, if a producer is denied the right to participate in a USDA program or receive a payment or benefit, NAD most likely has jurisdiction to hear that appeal. We've got some examples of appealable adverse decisions, and we've mentioned a couple of them on the previous slides. Denial of a right to participate in a USDA program is a big one. Denial of amount requested for a farm ownership or operating loan is another area that sees a lot of NAD complaints filed. Denial of equitable relief by the USDA agency, which we'll get into a little bit further on in the presentation, or failure to act. Has your contact at a USDA agency repeatedly failed to act on a decision or a question that you've put before them as it relates to a program benefit or payment? I wanted to highlight some of the most commonly appealed adverse decisions in a few programs that are really relevant to native producers. The first one is FSA. Payment limitation and eligibility is one of the largest areas that receives NAD complaints. Loan denials and denial of indemnity and disaster program eligibility or payment. So if you are part of a disaster program that you end up not getting a payment for when a disaster occurs, that's a big area where a lot of people have NAD appeals. EQIP under NRCS is another big one. Wetland determinations. So if you are looking for a determination that you live or have property in a wetland, those decisions often get appealed to NAD. And same thing with the Conservation Reserve Program, or CRP. And then if we skip over to 4 in rural development, the single family housing program is another area that sees a lot of NAD appeals, as well as denial of grant program funds like the value added producer grant. Just one caveat to NAD's jurisdiction in these areas. As it relates to crop insurance, it's a bit more limited. NAD is authorized to hear appeals of adverse decisions issued to a participant by one of those agencies we listed a few slides ago. It's super important that it is coming from the agency, that adverse decision is coming from them. However, with crop insurance, while the risk management agency and FCIC are the USDA agencies that are over the program, they are often not the primary point of contact for insureds, and this role is often left to the approved insurance provider, or AIP. And unfortunately, a lot of times, decisions that are made and issued by the AIP are not appealable because they're not actually coming from one of the agencies under NAD jurisdiction. So if you have an adverse decision in a crop insurance matter, in terms of NAD, the adverse decision has to flow down from one of those USDA agencies, either at FCIC or RMA. What cannot be appealed to NAD? Applications for program benefits are not appealable. Matters of general applicability is a big one, which we'll discuss later on in this presentation. And then another big one is complaints on the basis of discrimination. These matters fall under the Office of Civil Rights and include complaints about race, gender, and religion. If you have a complaint that's related to one of those, it's likely that NAD's not going to be where you end up filing the complaint because they're not technically over that subject matter jurisdiction. So briefly, what are the NAD filing rules? The NAD appeal, we've got them highlighted over here, must be in writing and signed personally by the program participant. So if you're the individual or your spouse is the individual that is technically enrolled in the program, that person has to sign off on it, even if it's let's say family farm situation. The appeal must be filed within 30 days of receiving the adverse decision in any format or medium. So if you get an email from USDA or another agency that makes you aware of an adverse decision as it relates to you, that's your notice and that's the beginning of your 30 days to file that appeal. It could be different. It could be based off of a conversation with somebody at a USDA agency. It could be something that's sent out nationwide, but essentially from the day of your notice of the adverse decision, you have 30 days to file that complaint. While those two are must, NAD filing rules also have a couple shoulds. So your complaint should be filed to the appropriate regional office, either the Eastern or the Western regional office. And your complaint should also include a statement as to why the decision is wrong. So if you're making a complaint about an adverse decision that affects your operation, that should be included in the initial complaint that you make to your NAD regional office. And then upon filing, the NAD regional office will assign an administrative judge or an AJ to the case, and the agency from that point is given 12 days to submit the agency record to you. So we mentioned in the previous slide that there are two NAD regions, and this map gives you that Eastern and Western split. So based off of what state you or your operation is in, will determine whether or not you are sending your complaint to the Eastern Regional Office in Tennessee or the Western Regional Office in Colorado. So we kind of got an idea of what NAD is and what its purpose is, what statutory basis there is for NAD, but what does the actual process look like for going through a NAD appeal? Our first step on the far left, you, the NAD participant, files an appeal to their regional office. The regional office will review the appeal for timeliness and jurisdiction. So they'll look to make sure that you got it submitted within that 30 days of notice and that they have actual jurisdiction to hear the appeal. At that point, the regional office creates the case record and begins the perfecting of it. Step 2, the deputy regional director assigns the case to an administrative judge. The AJ will, at that point, schedule a pre-hearing to narrow the issues of your complaint. And the administrative judge will also hold a actual hearing after the pre-hearing within 45 days of when you filed your complaint. So if you filed your complaint today, Thursday, August 21st, per their regulations, you should have your hearing on the complaint within 45 days from today's date. And then third comes the administrative judge's decision. The AJ will rule whether the agency decision was an error or not, and either the appellate, so the person who's appealing the issue, or the agency in question may request director review of the administrative judge's decision. And that's the director of NAD, which we'll touch on a little bit more here in a bit. What does NAD consider an appealable issue? So first, we've got general applicability. NAD has the authority to adjudicate decisions that are adverse as applied to you, the individual participant. However, if it's a rule, regulation, or policy that is generally applicable to all participants that directly causes the adverse decision or action, it is not appealable. So while NAD considers appeals from everybody who submits one, if it's a matter of general applicability, so if the issue applies to you and every other person who's a part of the program, that's something that's going to be out of their jurisdiction. Instead, it would have to apply, the situation has to apply to you individually, or the adverse decision has to apply to you individually. And then for final decisions on appealability, NAD's director has the final say-so. The director has the authority to determine whether an adverse decision is appealable. And if an agency rules a decision is not appealable, the agency must notify the participant of NAD appeal rights, which takes us into NAD's director review. So let's say that you have submitted an appeal and it's been determined that, or the agency has determined that it is a non-appealable finding. What do? You submit a review request. So a participant who has been notified that the agency decision is not appealable may file a request for an appealability review from NAD no later than 30 days after the receipt of the agency ruling on non-appealability. The review request must be in writing and focus on facts demonstrating that the adverse decision is adverse specifically to you and appealable specifically. In other words, you're arguing that this is not a situation of general applicability. But it's important to remember that an appealability review determines only if an adverse decision may be appealed, not whether the agency erred in the decision. So again, if you're going through this process and the administrative judge initially decides that you have submitted a non-appealable complaint, you then have the opportunity to request a review request that will go to the director of NAD, who will make a determination on whether or not you can actually appeal this decision. Kind of backing up a little bit, so we've got an overview of NAD, an overview of how appeals work, and what matters of general applicability are. So we are now going to talk about the NAD pre-hearing, which is the first face-to-face step or Zoom-to-Zoom step that you'll have in your NAD filing process. So after your appeal is submitted, the assigned administrative judge will schedule a pre-hearing conference call, and it's designed to help the parties, both you, the participant, and the agency, prepare for the hearing and potentially even resolve the case on your own. During this proceeding, the AJ will both identify the issues and the parties. So that could be the actual party, the person who filed the complaint, an interested party, or a third party. The administrative judge will set the date, time, location, and type of hearing. So either a record review hearing where they will just look at the agency record, or an in-person hearing where you will actually be before the administrative judge, again, either in person or on Zoom. And the administrative judge will also explain the hearing process and provide parties notice and opportunity for rescission. So at that pre-hearing conference, you'll get an overview of what the hearing is going to look like. You'll have the issues that are going to be argued at the hearing solidified, and you also have the opportunity to back out. Pre-hearings occur in every case, and they are recorded. You may obtain a free copy of the recording, which will be an official hearing transcript, so like a actual video recording that has the entire hearing on it. And upon written request, you can get a verbatim transcript. So either party may request the verbatim transcript of the pre-hearing or hearing. And the requesting party must pay for the service and provide a copy to the judge. So everybody will get a recording of the hearing, but if you want a transcript that has line by line what was said, that'll be an extra fee outside, or that'll be a fee outside of the NAD process that you'll pay and give a copy of it to the judge. So there's not a set cost for the service. It'll be calculated on how many pages are in the transcript. And if you do end up requesting one, you must allow the other party to purchase a copy from you as well. So what are some pre-hearing issues? As we talked about before, the administrative judge will inquire about interested parties and third parties. So let's define those. An interested party for purposes of NAD are often guaranteed lenders or reinsurance companies who are not parties but have an interest in the outcome of the appeal. So their rights are not affected by the appeal determination. Third parties are a little bit different. These are often spouses, former spouses, children, siblings, co-owners of your operation, etc. And they have the right to participate in a NAD appeal hearing. Third-party rights are not affected by the NAD decision, and third-party rights are affected by NAD decisions, and they're bound by the final determination, regardless of whether or not they participated in the hearing. Two other issues that will come up in the pre-hearing conference call are bankruptcies and mediation. So if an appellant or a third party is filed for bankruptcy protection, the NAD appeal must be dismissed, so it can't go forward unless the bankruptcy court judge authorizes NAD to move forward with the appeal. So if you are in an active bankruptcy or if a third party is in active bankruptcy, NAD is most likely not going to happen, or your NAD appeal is not going to happen unless you go to the bankruptcy court and ask the judge to authorize that the NAD filing process can continue forward. And then mediation is something that you can request in your NAD process. However, NAD does not require mediation in any case. If you do end up going with it, a mediation request tolls NAD's statutory timeframes. So if you end up going through mediation, there's going to be a pause on those 30-day filing rules, the time period that you have to request director review. All of that will be told while you are, or paused while you're in the mediation process. So after the NAD pre-hearing, we move into the NAD hearing. Following pre-hearing, NAD participants have a period to prepare for the NAD hearing. This is not a defined period, so there's not a set number of days that you can expect between the pre-hearing and the hearing. However, what you can expect is that from the date that you file your completed complaint, or your perfected complaint, within 45 days from that date, you will have the NAD hearing. So while there's not a set number of days between the pre-hearing and the hearing, within 45 days of the original complaint being filed, you will have the NAD hearing before an administrative judge. Another little timeline piece, even though we don't have that period between the pre-hearing and the hearing specified in any place, there will be 14 days notice prior to the hearing. So you can expect at least 14 days between the pre-hearing and the hearing, although it could be longer. Another just kind of overview of what the NAD hearing will look like. It's generally separated into 4 parts. First is housekeeping. The administrative judge will reconfirm the issues that the parties decided on in the pre-hearing conference. They will put the parties under oath and again explain the hearing process. Both sides have the opportunity to make an opening statement that gives a brief statement of your position, and the administrative judge will enter the agency record and exhibits that you present and resolve any objections to documents that come forward. Evidence and testimony will be given by each side, where you will be able to explain your case in detail by presenting testimony and documents. There's an opportunity for questions and rebuttal from the other side, and there's a good chance that the administrative judge will also have questions in addition to what the other party has. And then there's the closing. So both sides will have the opportunity to make a closing statement where you can reemphasize the main points of your argument and try and give the judge kind of a take-home statement for why this adverse decision is appealable and should be decided in your favor. And after that period that both parties give their closing statements, there'll be a brief wrap-up by the administrative judge. So what are some best practices to prepare for your NAD hearing? Maybe the most important thing is to have the agency record in front of you. It will be provided as part of the NAD process. It's important that you're familiar with it and the regulations that your argument is based on. So you'll want to be able to point out what specifically in the agency's decision-making process in paper in front of you is the point of contention, and be able to reference that as you're giving your opening statement and then throughout questioning. You want to organize the presentation of your evidence, which we'll touch on in the next slide. And then you'll want to formulate a strong opening and closing statement that explains to the administrative judge why the adverse decision should be decided in your favor, or why the outcome should be decided in your favor. So we've mentioned documents and testimony a few times. So what's the actual process for bringing documents into the NAD hearing? It's pretty simple. This is not something that follows really strict rules because we are not following the federal rules of evidence in NAD hearings. Essentially, all you have to do is label any documents that you want to present in your hearing as exhibits with the page numbers listed on every page. So let's assume that you have outside of the agency record, 3 documents that you want to present. Each document is 10 pages long. The way you would present those to the court is by labeling the document, the first document, Appellate Exhibit 1, and then on the bottom of the page, you would write page 1 of 10, page 2 of 10, page 3 of 10, so on and so forth. And then for the second and third document that you've brought, the only change would be that they would be Appellate Exhibit number 2 and Appellate Exhibit number 3, with each page marked in the bottom. Everything submitted after the hearing is labeled in the same way, except instead of labeling it as Appellate Exhibit 1, you'll label it as Appellate Post-Hearing Exhibit 1. So you're acknowledging that these were submitted after the hearing to be part of the overall record. So we've talked about the pre-hearing, hearing, and then documentation, including post-hearing documents. So what is the post-appeal hearing like? Following your hearing, the record closes and the administrative judge has 30 days to issue a determination, 30 calendar days. So after the appeal determination is entered, both the USDA agency in question and you, the participant, have the opportunity to request director review. So that's where the NAD will come in and make a determination on whether or not this the final determination was appealable and whether or not you basically have another chance at addressing your complaint. So for the agency in question, they will have 15 business days after the appealable determination is entered to file that director review request, and the appellant, you the participant, will have 30 calendar days to request the same. So after the appeal is determined and a decision is entered, you the participant have 30 days to come in and say, we don't agree with this. We'd like director review of NAD or NAD director review, and you can begin that process. And then just as a reminder, interested parties that do not become third parties may not request director review. So giving an overview of NAD, kind of a summary, final points to keep in mind. First one we want to hit on is the finality rule. An appeal determination is a final administrative action on the issue unless a director review is requested. So as we talked about in the previous slide, the appeal determination comes down within 30 days of the close of the case. And unless director review, if it's you that's requesting director review, is made within 30 days, if you don't make that, then the appeal determination is final and there's nothing else that you can do about it through NAD. Absent a request for a director review, like I said, the determination is final 30 days after it is issued. And if no director review is requested, the administrative judge decision becomes the final agency action on the matter. This means subsequent legal action must be filed in U.S. District Court. So again, if you don't file director review in a scenario where you want it, that decision that you want a director review on will become final, and the only avenue for you to pursue it further would be by filing suit in federal district court. Equitable relief. Another really important point that we talked about on the second slide. When an agency head has authority to grant equitable relief, the NAD director has that same authority. Administrative judges, however, have no authority to grant equitable relief, but must prepare the record for the director to consider. So the agency head has the authority to grant equitable relief. The NAD director has the same authority. If the agency head does not have authority to grant that, and the NAD director does not. But in any case, administrative judges do not have that authority. So if equitable relief is an issue, then it's something that is going to have to go to the NAD director in a director review request. And then secondly, the appellant may appeal an agency's denial of equitable relief. In such cases, the administrative judge will make findings of fact and draw conclusions as to whether the agency erred in denying relief. So again, that's the top level that you can go to within the NAD filing process without continuing forward to file suit in federal court. Another super key point that we've been talking about throughout the presentation is director review. Again, requests for director review from the appellant or third party must be filed within 30 days of the receipt of the appeal determination. So 30 calendar days from whenever the appeal determination is handed down, that is your period where you have the ability to take it one step further and request director review of that decision. Agency requests for director review have to be filed within 15 days as opposed to the 30 days that participants have, and interested parties may not request director review. And then finally, determinations of the NAD director, both on the merits and regarding whether an issue is appealable, are administratively final. So whatever happens, the NAD director's final determination is a final administrative decision that is binding. Again, the only way to go above and outside of that is to then file a suit in federal court. And then finally, in all caps, because it's so important to remember, exhaust your remedies. NAD exists to provide parties with administrative remedies. And because Congress has mandated that all admin remedies must be exhausted prior to filing suit in federal court, in many circumstances, you must, all caps must, pursue an appeal with NAD in order to exhaust your administrative remedies prior to filing a suit. What does this mean and why does it matter? It matters because if this is a use it or lose it right. If you don't use the administrative remedy through NAD on an issue that's in their subject matter jurisdiction, you will likely lose the ability to pursue any type of remedy in that scenario. So if it's in a decision that's within NAD's subject matter, if you don't go through the NAD filing process or the NAD appeals process, you are barred from then pursuing it in federal court. What does this mean? It means that time is super important. Time really matters. Those 15 and 30-day deadlines that we've touched on throughout the presentation, that's what we're talking about. Oftentimes from the beginning of your knowledge, that's when the time clock starts running. And if it's not submitted within that period, then whatever adverse decision was made by the agency is a decision that's final. And there won't be other remedies for you to pursue, other legal remedies for you to pursue on the matter. So time really matters. It's important to pay attention to those filing deadlines and the response deadlines if you are in the middle of a NADS appeal. And failure to do so could result in the unfortunate and binding final appeal determination. And I think just one more note on that kind of goes unsaid is records in general are your records, your farm records, your financial records are crucial in almost any dealing that you have with a USDA agency. In almost every scenario, they're going to want some proof that you are actually farming or actually engaged in the practice of farming or ranching. They want to know that you've actually been a part of this program, that you've complied with program requirements, that you have essentially done your due diligence. And the way that you prove that is by having your records available in hand to show. I want to drive the point home a little bit further because it works so closely with why time matters. If you have agency records, let's say at FSA, and some adverse decision comes down that implicates your rights or your ability to participate in the program, it's crucial that you have the records on hand in order to successfully file a complaint and enter evidence before a hearing before a NAD administrative judge. Why is this relevant? A lot of times it takes longer than 30 days to receive records. It's going to be dependent on where you're at in the country, how responsive the regional agency is, FSA or RMA or NRCS. They're all going to have different response times. And if you're in an area where maybe the USDA agency in question has a track record of not responding timely, you could end up in a situation where you don't have the relevant documents that you need to prove your case. So you're up against a time clock that you really don't have any control over. So it's always good practice. My boss says at least yearly to request records from any agency that you have dealings with so that you're keeping your own hard file records in your house or your office up to date on a yearly basis so that if something does happen and you need to act really quickly, you have everything you need to be successful on the front end. And then finally, I just want to hit on this resource page. It will go out after our presentation and Q&A is over. And all of these links are hyperlinked, so we'll be able to click on them and it'll take you directly to the resource that we're talking about. A few just to specifically highlight. NAD was created in 1994. There have been a handful of statutory and case law updates, but not many for that long of a time period, 31 years. And there's a really great, or because of that, there's a really great guide that's pretty old. I think it was created in 2003 or 2004, but it's comprehensive and there's a significant amount of information on the filing process, timelines, best practices, all of that info that's contained in the Farmers Legal Action Group manual. It's called NAD, sorry, it's called NAD Procedures in Practice. Another really incredible resource for anything NAD related is the National Ag Law Center. Their entire website is full of resources, but that's where a lot of NAD information is housed from over the years. And then secondly, in the second white box, we've got enabling statutes. We talked about those at the beginning of the presentation, and they're just good reading or good information to have on what and why NAD exist, and how it continues to function today as a method to timely address complaints within USDA programs. And then also the Farm Security and Rural Investment Act of 2002. It talks significantly about equitable relief from ineligibility for loans, payments, or other benefits. And this section amends NAD's enabling statute. And then finally, we have equitable relief reports from NAD for the majority of the last 6 years. I don't believe the 2024 report has been released yet, but I'm sure it's incoming. And this is another place to just get more information on it and see how NAD decisions have been made in the past. And that completes the brunt of the presentation or the information that we're covering today. I want to open it up to questions that you may have, and I'll do my best to answer any specifics.
Okay, everybody should have the ability to take themselves off mute and ask any questions that they might have. And I will say, while you guys are thinking of some of those questions, I did share a link in the chat. If you guys wouldn't mind taking that short survey, I don't even think it takes about 5 minutes. I think I timed it earlier and it took me about 2 minutes and 10 seconds. We would really appreciate it. Justine, thank you so much for your comment. We're really glad that you enjoyed the information. Matthew, yes, the slides will be shared. I will be sending out a email that has a copy of the presentation. It also will have a link to our YouTube channel where a copy of this recording will be located. And I will share info about our next webinar for the third Thursday of September. And so be looking for that email. It will probably come out late tomorrow or potentially on Monday, depending on how fast I can get that the recording uploaded. Does anyone else have any questions? If not, I want to thank Ridge for his time today. I thought it was a very wonderful presentation and I personally learned a lot. So thank you for your time today, Ridge. And we hope to see everybody on the third Thursday of September.
So happy to be here. Thank y'all for coming.
Oh, thank you very much. It was very informative. Do appreciate it.
Of course.